Hello, I'm Andrew O'Hare, Executive Editor of Salon. Welcome to Salon Talks. This is going to be a hot one. Joining me today is Andrew Coan, who is a law professor at the University of Arizona. Welcome, Andrew.
Thanks, my pleasure.
And Andrew is the author of a book which is called Prosecuting the President: How Special Prosecutors Hold Presidents Accountable and Protect the Rule of Law. And Andrew just assured me there has been no collusion between him and the U.S. Senate or Special Counsel Robert Mueller to make this book especially relevant at this time. But with Attorney General Designate Bill Barr before the Senate today and yesterday, you could not possibly have timed this better, I think.
I think that's right, but it was just sheer luck, I assure you.
Now, this book is, among many other things, a really, really fascinating history of the role of special prosecutors in American history. Now, anybody who's writing a book about political history or legal history wants it to be of contemporary relevance. I assume you started this knowing that Mueller had been appointed and that it would be relevant for that reason, right?
I did. I started writing this book last February, so I was very well aware of the special counsel's current investigation, and that was a big part of my motivation for writing the book. Sure,
and it is, but trust me, people, the history is not irrelevant, especially the history of the Watergate investigation and Special Prosecutor Leon Jaworski, and the history of the Bill Clinton investigation, the Lewinsky matter, and Special Prosecutor, I think. We'll talk about the terminology,
sure.
Ken Starr, but that's correct in those two cases.
That's right. Special Prosecutor is a generic term that refers to any kind of outside prosecutor appointed to investigate the president or his administration. Independent counsel is a specific term that refers to a kind of special and especially powerful special prosecutor that existed for only 20 years between 1978 and 1998 as the result of a post-Watergate law, which was then allowed to lapse after Bill Clinton's impeachment.
Largely because of the Ken Starr investigation.
Because of the Ken Starr investigation, although also because of Republican concerns about Lawrence Walsh's investigation of the Iran-Contra affair. Each side had a kind of independent counsel that they could demonize, sort of Exhibit A for why the special counsel, or the independent counsel, as it was then called, had grown too powerful.
Yep. Now, I do want to circle back. There's so much to talk about here. I feel like we could go on for an hour, but I do want to circle back to current events and what's going on right now. Could you possibly have imagined when you started this? I mean, you understood, you've obviously studied this stuff, you understood what Mueller's brief was and what he was supposed to investigate. Could you have imagined, could you have anticipated that he was going to investigate the President of the United States as a possible Russian agent?
Well, I think that has been on the table from the very beginning of this investigation. I think it's important to emphasize that we don't know yet what he has found in that investigation, or even whether that aspect of his investigation remains ongoing.
Indeed.
The New York Times, of course, confirmed on Friday of last week that the FBI, senior officials in the FBI, opened what they call a sub-file, a special investigatory file, to investigate whether the president was acting either wittingly or unwittingly, and there's another important distinction on behalf of Russian interests when he fired FBI Director James Comey. When Rod Rosenstein, shortly thereafter, appointed Robert Mueller as a special counsel, then Mueller inherited that investigation. We don't know, since Mueller's operation has been basically leak-proof, whether that investigation remains ongoing or exactly what it has turned up.
Right. I think those are all very, very important caveats, and it's very easy, especially for people in the media, to get way ahead of the news. Obviously, this was an explosive report, but even if everything that the Times reported is true, it is important to note that we simply don't know what Mueller has found or has not found, and whether he's still actively investigating that. All of that remains shrouded.
That's true. Although, I mean, I think it is fair to say that it is shocking and unprecedented to think that the senior leadership of the FBI concluded that there was sufficient factual basis to at least begin an investigation on this front. That's a pretty big deal.
So is this then, I mean, I don't want to come off as overly partisan here, and I know neither do you, but does that make this the most explosive of all of the special prosecutor, special counsel investigations? I mean, Richard Nixon was clearly going to be impeached and probably convicted in the Senate. He covered up a burglary. you know, no one accused Richard Nixon of being the agent of a foreign government, wittingly or unwittingly.
This is potentially the most explosive special prosecutor investigation in U.S. history. But we're really not going to know the answer to that question until Robert Mueller files his report with the Attorney General. It seems likely that that Attorney General will be William Barr by the time the report is complete. And of course, then there'll be a question about what William Barr does with that report. As many senators pushed him on yesterday, under the current regulations, the special counsel regulations, which date all the way back to 2000 and the post-Clinton impeachment era, the special counsel is required to file a confidential report with the Attorney General at the conclusion of his investigation. And that was in part a response to the perceived excesses of Ken Starr during the Clinton investigation. Ken Starr published a thick and salacious report on the Monica Lewinsky affair, forwarded it to the House of Representatives. Starr did not himself make it public, but Newt Gingrich and the House Republicans at that time immediately did choose to make it public. And there were a lot of people who thought that really didn't serve the public interest. There was a lot in that report which was simply of prurient interest rather than legitimate investigative interest.
That seems fair to say. Yeah.
And so, in response to those concerns, the current special counsel regulations, drafted by Bill Clinton's Justice Department staff, require the special counsel to submit a confidential report. And then it's up to the Attorney General, who is, of course, accountable to the President and will face significant political pressure to release this report to make a decision. And it's a little bit hard to parse the testimony of William Barr on this point. He definitely made some strong opening commitments to transparency, strongly suggested that he believed that the American people need to see a credible resolution to the issues that Robert Mueller is investigating. But he also would not commit to releasing the full report and offered various caveats about exactly what he might disclose or not disclose, both to the public and to Congress.
Yeah, as you say, it was a little hard to read Barr's testimony, and there's been all kinds of speculation in the ensuing hours. I read him, and tell me if you disagree with this, as being extremely careful. He's a former attorney general. He obviously knows the law. He is also, rightly or wrongly, suspected of having a strong partisan interest. He's identified as a conservative Republican. He has seemed to endorse possible investigations of Hillary Clinton that sound to many of us like right-wing fringe conspiracy theories. And it struck me that he was trying to walk a very fine line between I'm going to be an attorney general for this Republican president who has a very strong constituency on the right, and I'm going to follow the letter of the law, and I'm a guy who knows about that. Is that fair enough?
I think that's basically fair characterization. He's certainly an extremely careful lawyer. He served as the Attorney General under President George H.W. Bush, and as a senior official in the Justice Department for many years before that. So he is, in many ways, on paper at least, one of the most qualified, one of the most experienced, certainly, Attorney Generals ever nominated to serve in that post, or one of the most qualified and experienced nominees to the position of Attorney General. And he was very careful and cautious yesterday, and I think it's a little bit difficult to know what to make of that. On the one hand, I think it would be unwise to overlook the wiggle room that he has left himself, and it will be important for the public to be vigilant if he is eventually confirmed, to make sure that he adheres to both the spirit and the letter, and maybe the spirit and not just the letter of his testimony before Congress yesterday, because he could adhere to the letter of his testimony, the literal meaning of what he said to the Senate yesterday, and withhold substantial portions of the Mueller report, and in fact exercise his supervisory powers over the investigation in various ways that would in fact substantially hamper Robert Mueller's work. I think the hope has to be, and the public pressure will play a large role in determining whether this hope is realized, that Barr really means what he says and that he lives up to the spirit of his remarks and not just the letter.
Now, I've always been of the point of view that regardless of what the Constitution says or doesn't say, it was extremely unlikely, bordering on impossible, that Mueller was going to indict President Trump for anything. You generally would seem to subscribe to that view, and part of that comes from Leon Jaworski and the Watergate investigation. Jaworski made a very clear decision not to pursue the indictment of Nixon. And so even though it isn't in the Constitution specified whether that can happen or not, the Justice Department rules, and Mueller is bound by those, correct? Justice Department rules seem to make it clear that that can't happen.
That's right. There's a current Justice Department policy first established during the Nixon administration and reaffirmed during the Clinton administration that a sitting president may not be charged with or indicted for a crime. It's also quite clear that a president who has left office because his term has expired or as the result of impeachment and removal by the Senate can be charged with a crime. But as long as Trump is a sitting president, I think it is virtually impossible, inconceivable to imagine Robert Mueller indicting him, for a crime.
So, but just to clarify that a little bit, possible crimes committed while holding the office of the president would not be immunized once you were no longer president. Is that fair?
Well, it depends on exactly what the crime in question is. One of the things that got William Barr in hot water yesterday and in the months leading up to his confirmation hearing was a controversial memo that he wrote in June of last year as a private citizen and sent to the Department of Justice, as well as the president's own personal legal team, arguing that a president cannot obstruct justice, cannot commit the crime of obstruction of justice when he is engaged in his ordinary constitutional responsibilities or exercising, and these are the exact words of the memo, I think, exercising the discretion vested in him in the Constitution. So this would include things like firing the FBI director or ordering the FBI director to drop an investigation into National Security Advisor Michael Flynn for his role in possible collusion with the Russian government during the 2016 campaign. On the views expressed in Barr's memo, the Constitution protects the president's ability to make those decisions for any reason whatever. So if you hold those views, or if a judge holds those views, the president could argue that he was acting under his constitutional authorities within the constitutional prerogatives of his office in taking those actions if he were to be charged with obstruction of justice. But just as a blanket matter, there is no immunity, there is no prohibition on the indictment of a sitting president for his conduct while in office, although it's never happened in American history.
And moving on from that to talk about an issue that came up in Watergate, which always fascinated me. I was a little kid at the time, and I remember some of this. That when Richard Nixon was named by the grand jury as an unindicted co-conspirator in the Watergate cover-up, which was a sort of intellectual and legal and legalistic compromise. Nixon was not directly charged with a crime, but he was named in that way. Now, as I understand it, I learned this from your book, the current Justice Department regulations discourage the use of this term or that language, the unindicted co-conspirator thing. Haven't we already come pretty close to that in the Michael Coan case, with Michael Coan's testimony, I believe under oath, that he was doing the bidding of the President of the United States, the Republican candidate for president at the time when he made payments to these various women, and that he has pleaded guilty to a crime, and essentially a criminal conspiracy has now been established in the courts. And even though that phrase has not been used, it strikes me that the unindicted co-conspirator in that case is perfectly obvious to all of us.
Well, the identity of the person that Michael Coan says directed him to make the payments, I think referred to as individual one in the court documents, is perfectly clear. Everybody knows that is President Trump, then candidate Trump. But I don't think we've quite crossed the line of Trump being named as an unindicted co-conspirator. In some of the immediate commentary in the immediate aftermath of the sentencing memo that the prosecutors in Manhattan filed on Michael Coan's case, some fairly eminent legal scholars said, yes, this is in fact amounts to the president being named an unindicted co-conspirator. I think they overlooked one crucial fact. It's really close, and it's really damning for the president. But the sentencing memo filed in Michael Cohen's case does not address Donald Trump's state of mind. And that's a crucial element of these campaign finance offenses. It seems likely, based on the sentencing memo and on the statement that Michael Cohen made when he pled guilty in this case, like the prosecutors probably have sufficient evidence to establish that the president had a guilty state of mind and therefore did violate criminal federal campaign finance laws. But because this isn't a charging document aimed at the president, it does not directly address that question, which is likely to be the crucial one if these charges ever were to come before a court.
Right. I note that Congressman Jerry Nadler, who's now the chair of the Judiciary Committee in the House, has said that he believes that is probably an impeachable offense, which does not mean that the president should be impeached for doing that. There's a couple of ways to read that, and I wonder how you see that. One possibility is that Nadler is saying, well, let's wait and see what else there is before we go down that track, and that maybe there's something that's even more clearly an impeachable offense that is still to come. Or another reading is simply that he's being cautious and saying, yes, a campaign finance violation is clearly against the law. It might not rise to the threshold of we should actually kick the guy out of office for it.
So I think that's basically right. I interpret him as saying, look, this offense meets the legal threshold under the Constitution for impeaching the president. We would be acting within our constitutional authority if we impeached the president for committing this offense, if we concluded, in fact, that there was a factual basis there to believe that he committed it. But the Constitution doesn't obligate the House of Representatives to impeach a president who has committed crimes and misdemeanors, or the Senate to remove that president. It gives them the discretion. Really, it imposes or creates a judgment call for Congress, both houses of Congress, and it's a very serious decision, one with enormous consequences for the country. And I think it's probably wise for someone in Nadler's position to approach this matter cautiously, because either way, however it comes out and whatever side you're on politically, impeachment is a wrenching process for the nation.
And, it's worth noting that no president has ever actually been removed from office through that mechanism.
That's correct.
And we can assume that it would have happened to Nixon, but in fact we don't know because it never went to a trial.
That's right.
It
seemed like a virtual certainty
Yeah.
in Nixon's case. The writing really was on the wall. In the summer of 1974, when the U.S. Supreme Court issued its decision in United States versus Nixon and ordered Nixon to turn over those famous White House tapes, including the smoking gun tape, which featured him ordering the CIA through his chief of staff to shut down the FBI's Watergate investigation. The House Judiciary Committee had already voted articles of impeachment out to the full House. And when they voted, 13 Republican members of that committee voted against impeachment. Several Republicans actually voted in favor of impeachment, which seems kind of remarkable today.
Yes,
but 13 voted against it, and that was a healthy fraction. In fact, I think a majority of the Republican members of that committee. But after those tapes came out, in particular after the smoking gun tape came out, which clearly showed Nixon trying to squash the FBI's Watergate investigation based on a bogus national security rationale, all 13 of those Republicans issued a public statement saying that they had changed their minds, that in light of this new evidence, even they would have voted to impeach the president. And that made it pretty clear to Nixon that he could not survive any longer, and he resigned very shortly thereafter.
And it's a little difficult to imagine anything like that occurring with President Trump. I realize that's political speculation, but it is hard to see that kind of climate emerging.
There are some key differences between the American political landscape in 1974 and today. I think that the two most important are what political scientists call the hyperpolarization of American politics today. This means that the American people and their elected representatives in Congress tend to see almost every issue through a partisan lens, and they see politics as a zero-sum game between the two parties. And this makes it very hard both for individual voters who are trying to think about these questions and for members of Congress who have to worry about their constituents, and a primary challenge possibly in the next election, to really examine their conscience and examine the evidence and try to look at these things through a nonpartisan lens. And the other key structural change to American politics since 1974 is this kind of populist moment that we're living through, in which the president has a kind of direct and visceral, personal relationship almost with a large subset of Republican voters, his base, his core constituency. And this has allowed President Trump to transgress political norms that no other president or political candidate could ever have gotten away with.
Clearly true.
And any Republican thinking about abandoning the president, and voting for impeachment or voting to remove him from office is going to have to think about those voters. On the other hand, what Watergate illustrates, I think, is that the American people are capable of changing their mind. When Richard Nixon was inaugurated for his second term in January of 1973, he had just won re-election by what was then the largest popular vote margin in American history.
Yes.
His public approval rating was 67% at the time of his inauguration. And by the summer of 1974, when he resigned the presidency, his approval rating had fallen to 24%, which means, of course, that tens of millions of Republican voters had changed their mind about the president in light of the evidence unearthed by the special prosecutor. And so things have changed. Our political environment is very different today than it was in 1974, but I don't think we should rule out the possibility that something in Robert Mueller's report might be capable of changing the public's mind and changing Congress's mind.
Two-part question. Unfortunately, we should wrap fairly soon, but I'm guessing I know the answer to this, but how much or how carefully do you think Robert Mueller has studied the history of previous special prosecutors and the outcomes of their investigations? And what lessons would you suspect he has taken from those?
I have no idea how closely Robert Mueller has studied the history of those investigations. If he's interested, I've got a great book that I could recommend to him.
Have you sent him a copy?
I have not sent him a copy. That seemed a little presumptuous to me, but I think he can find one.
You can find it on Amazon,
if he's looking for it. Everybody knows where to go to find books these days.
Yeah.
I think the principal lesson of this history is really not so much a lesson for Robert Mueller, although it has implications for him, but a lesson for the country, which is that special prosecutors like Robert Mueller are incapable of saving us from ourselves.
Thank you, yes.
And at the end of the day, whether the president is above the law is ultimately a question for the American people. And I think we're having a moment like that right now really at this very moment, literally, during these Barr hearings, where public scrutiny has really forced the president to nominate a basically credible Attorney General candidate, although one about whom some very significant concerns have been raised, and have forced that candidate to make some really significant commitments on the record to allow the special counsel to complete his investigation. As I mentioned earlier, there are certainly some reasons for concern about Barr as a nominee, and based on his testimony yesterday, he's left himself some wiggle room, as you would expect a careful lawyer to do. But I think the big takeaway from these hearings is the one that's been dominating the headlines. Barr has committed to allow Mueller to complete his work. He has said, in response to a direct question, that he would not fire Robert Mueller without good cause, even if the president ordered him to, that he would resign before he would take that action. And that is a big deal, and I think we've gotten to this place improbably because the American people have been paying attention, not all of them, and not all of them have, of course, been analyzing these issues through a nonpartisan lens, but enough of the American people have been paying attention that it has placed substantial pressure, even on this unorthodox, norm-smashing president, to allow this investigation to go on, despite his own obvious desire to fire Robert Mueller as far back as June of 2017. It's really quite remarkable when you think about it, that all this time, President Trump has had the power to get rid of Robert Mueller, to squash his investigation. He is the most powerful man in the most powerful country on earth, and yet Robert Mueller has managed to survive. And the reason he's managed to survive is because even Trump knows that the political consequences of firing Robert Mueller or significantly interfering with his investigation would pose a grave threat to his presidency. And that, I think, is an example, an illustration that the American people are still capable of doing their job, although there have been some really close calls, and we're not out of the woods yet.
Yeah, thank you so much for saying all that very, very quickly. And I know you're, as a law professor, you're going to be very careful about this. What do you think will come out of the Mueller investigation, and what do you hope will come out of the Mueller investigation?
Well, I'm actually going to punt on that question altogether. I'm sorry to disappoint you and sorry to disappoint your viewers. I just think it would be irresponsible to speculate on that question. But I will say that the reason that we have these investigations is to find out what happened. And so I think that both liberals and conservatives have tended to think about this in the wrong way. I think liberals, it's become really an article of faith among liberals that if Mueller is allowed to complete his investigation, that he's going to produce a really damaging report. And I think conservatives secretly share this belief, which is why we see them attacking Robert Mueller so relentlessly.
Oh, I don't think it's a secret at this point, but yes.
I mean, you don't typically attempt to destroy the person that you think is about to exonerate.
Yeah.
But I don't think we know enough to be confident that this report will, in fact, be as damaging as either side assumes. There are a lot of key questions that we don't yet know the answers to. There's a huge amount of smoke here, and there seems almost certain to be some kind of fire. But exactly how big that fire is, who's involved, who started it, we really don't know yet. And so I think it would be irresponsible to speculate at this point. What I hope most of all is that Mueller is allowed to complete his investigation without interference, and as William Barr mentioned in his testimony yesterday, that the American people get what is vitally necessary for all of us today, which is a credible resolution to these issues.
Such a fascinating conversation. Andrew Coan, professor of law at the University of Arizona and the author of Prosecuting the President, How Special Prosecutors Hold Presidents Accountable and Protect the Rule of Law. Read it. Andrew, thank you so much.
Thank you.